Hi, I'm Janet Payton. I'm a partner with McGuire Woods, and I spend a lot of time working with our clients' marketing teams, as well as their in-house lawyers. Welcome to the first episode of our Frenemies series. The intellectual property and data privacy teams here at McGuire Woods have teamed up to present this short series of totally bingeable, user-friendly videos about the often seemingly confounding issues that affect marketing practices. We know that there's a natural tension between the marketing folks and the lawyers. The marketing folks are often young, creative risk takers who understand how to engage customers. And lawyers are often not so big on risk-taking and more concerned about potential liability and exposure than the impact of a great campaign. Our goal is to make the lives of both marketing and legal a little easier by breaking down the issues and providing marketing and insight into the vast legal and compliance universe, which may present itself as a hard no sometimes by legal. We hope this series allows you to make friends with your lawyers and they with you. Thanks for watching. So first we're going to start with, what is a trademark? Trademarks are words or symbols or designs or combinations of those things that a provider of goods or services uses to identify the source of its goods. It's a brand. A trademark is a brand. So for example, McGuire Woods, that's our brand. Sometimes we use it in a stylized format and we think of that as our logo. And then we could have a brand that has more than one word, like a tagline, relationships that drive results. Brands get put on packaging or they get, dropped into glossy marketing pieces. And it's important to think about picking brands that you can protect and defend against infringers. So why have a trademark and why register it? A trademark attracts attention. A trademark is a symbol of the goodwill that the public associates with your product or with your company. It creates a conditioned response. When they see that brand that they recognize and they know they like, they reach for it instead of a generic alternative, right? So a brand is its own goodwill. That's really all it is. If you have a brand that's never been seen by any consumer, it's nothing. It doesn't have any meaning. It doesn't have any value. A brand only has value through use in public. And so you're going to hear that theme that you've got to use these marks in order to keep them, and you have to use them in order to register them. So when do you own a trademark? When you use it in commerce with a good or service so that consumers begin to identify it as a brand for that thing or for that company. You don't have to register a trademark to own rights in it. You can have common law rights as soon as you start using the mark in commerce. And if you've been using them for a long time in commerce, then you acquire more and more common law rights. So common law rights are really useful. They are an asset, but common law rights are tied to geography. They're tied to your actual use. And so if you've really only used the brand in a little corner of the country and you've never advertised outside that geographic scope, then your common law rights are limited there. Whereas if you have a federal registration for your trademark, you're the presumptive owner throughout the United States. So the benefits of federal registration, as I said, presumptive ownership is one, but they also gives you the right to use that encircled R. The R is really helpful. It puts people on notice that you are the owner of a federally registered mark, and they shouldn't even think about copying it or trying to pick a mark that's too close to it. Once you have a federal registration, it also gives you access to federal court in any dispute. Federal court is really where you want to be for any intellectual property matter. Generally, state courts don't spend much time on IP, and sometimes you can get funny results in state court, so it's really good to have access to the federal court. And using those symbols, as I said, can give you a deterrent effect with infringers. And even before you're registered, you can use a TM or an SM to indicate that you're asserting ownership, even if you don't have it registered yet. That's why sometimes you see a TM, but once you get to registration, you'll see the R. In the world of patents, which we're not talking about today, this is sort of like the difference between patent pending and patent. So TM, think of that as like trademark pending. So here's where the conflict comes in. And these are the things that lawyers worry about. When you're considering adopting a new brand or modifying an existing brand, have you thought about whether or not that mark can be registered? Does it infringe somebody else's mark who's already using it for a similar product or service? And are there any unintended consequences or costs of doing that, either modification or launching that new brand? So let's talk about whether or not it conflicts with other marks. If it conflicts with other marks, then you're at risk of being sued for infringement. And it's also potentially going to be rejected by the Trademark Office. When you apply to register a trademark, the Trademark Office will examine the application and compare it to other prior registered marks. If the trademark examiner thinks it's too close to a registered mark, he or she will refuse to register it. Even if the prior owner isn't registered, there's still a risk of a federal infringement claim. An online search by itself is a good way to start your trademark analysis, but it's not nearly enough. It's really important that you do more than just Google the mark. So, is the mark distinctive or is it merely descriptive? This is another way that you could inadvertently pick a mark that can't be registered. Descriptive words can't be registered as trademarks for the thing that they describe. Descriptive words that have nothing to do with the product can be registered, but you can't register the word apple for apples because everyone has to be able to call apples apples without getting sued. If you pick a name like that for a different kind of product, you might be able to think of one, then you can probably register it if someone else hasn't thought of it first. Descriptive marks are weak and they can't be asserted against other people. So if you're trying to claim that you have a trademark for apples and the trademark is apple, you're never going to be able to stop other people from using that mark. And so it's a very, very weak brand. It's basically not a brand at all. The best kind of trademarks from a legal perspective, although not always from a marketing perspective, are arbitrary or fanciful marks. These are marks that are sort of the opposite of descriptive. They have no relationship to the goods or services. They're made up either terms like random consonants and vowels strung together that make a cool sounding word and that were just selected for the purpose of being that brand, or they're words that are in fact actual English words but have absolutely nothing to do with the product or service you're offering. When you choose an arbitrary or fanciful mark, that mark is going to be a very, very strong brand in terms of its ability to be registered and your ability to fight off infringers. So those are the pros of picking a mark like that. But there are significant cons from the marketing team's perspective, and that is, if you have no idea what that brand means or what it relates to, you're going to have to spend some marketing dollars in advertising to educate the public. If you don't have money for a Super Bowl commercial or two, then you really might struggle choosing an absolutely arbitrary mark. Suggestive marks imply what the good or service is, but they don't come right out and say what they are. So, like an arbitrary mark, these are still pretty strong and pretty easy to register as long as no one has thought of it first for the same kinds of goods. It does still require a certain amount of marketing effort and dollars to teach the public what that is a brand of, but the fact that it's suggestive gives the consumer a hint. It helps them in that education, and it reminds them when they see the brand, oh yeah, I know what that is. As we said a little bit ago, descriptive marks describe something about the product. They describe a quality of the product or a feature of it, or they just describe the whole product itself. And so those are actually not marks that can be registered initially. They can be registered eventually if they're used as a brand for so long that the consumers start to recognize that as a brand name and not as a description. Eventually they can be registered, but that takes time and money as well. So while this one ends up on the pro side, maybe from a marketing team's perspective, because they don't have to do much consumer education about what the product is, it's definitely got some cons on the legal side. It's not going to be easy to register. It may be impossible, and it may be very, very difficult to protect or to keep third parties from choosing that same mark or very similar mark for the same kinds of products. Lastly, we have generic terms. I won't even call these generic marks because a generic term can actually never be a trademark. A generic term like Apple for apples has to be available for everyone to use to call those things what they are without getting sued. You know, it's like a First Amendment thing. Free speech, we have the right to call apples apples, and I can sell them and call them that for as long as I want. The problem is that's not a trademark at all. So there's really no pros on the trademark side for lawyers or for marketing people with respect to generic terms. And the cons are sort of the same. It's not a trademark and it never can be one. So just don't even think about trying to register a generic term. So here's a little review. This is a spectrum of distinctiveness. This is what we've been talking about today, with arbitrary and fanciful marks like Yahoo for a search engine. That word did exist in the English language before it became a well-known search engine, but it doesn't have anything to do with the internet or searching or anything. And so it's a really, really strong brand now that it's been built. A suggestive mark like Snapchat is also an easy mark to protect because it doesn't say what it is either. But the difference between a mark like that and a mark like Yahoo is that Snapchat hints at what it's about. It's snappy. It's got something to do with being quick and fast and something maybe to do with chatting. And it kind of goes together to create an impression of something that has to do with communication. But it doesn't tell you that it's a social media app. It doesn't tell you what it does. It's not descriptive. It's suggestive. And that is a sweet spot. Then you have descriptive marks that have been used in commerce for so long that they've acquired distinctiveness, and they can be protected as a trademark, like Kentucky Fried Chicken. On the first day of Kentucky Fried Chicken's existence, that didn't sound like a brand to anybody. It sounded like fried chicken that came from a particular state. But now we all recognize that as a very specific, famous even brand, and it is a brand that can be protected because it's been used for so long. So descriptive marks eventually, sometimes, especially if they're more than one word put together, can begin to be recognized by a consumer as functioning as a trademark. It just takes time and money. And then you have generic terms that can never be trademarks, like grocery store. Grocery store will never be a trademark for grocery stores. It just can't function that way. Trademark lawyers love it when you choose a strong arbitrary brand name because it's so easy to protect and to exclude others from using it, while the marketing folks really, unless they have a gazillion-dollar budget, are leaning in the direction of descriptive marks usually. So the real sweet spot, as we said, is right there in the middle, suggestive marks. That's the best place to be. We really encourage you to try to think up those brilliant suggestive marks that hint but don't tell you. So a funny thing can happen with this straight line though. Sometimes an arbitrary or fanciful mark becomes so famous that it starts sort of leaning towards being a generic term. I actually think you could probably think of some famous brands like this. Like for example, Kleenex is a trademark of Kimberly-Clark. And Kleenex is a mark that has definitely put a lot of effort into making sure that it doesn't become generic. Kleenex is a brand name, and the generic term is tissues. So when you see that brand out in the world, the owners have taken great pains to make sure you remember that tissues is the generic term by putting that on the box. So any box of Kleenex brand tissues you'll see says Kleenex with an R, and then underneath, brand tissues. That's a reminder that it's not a generic term, and not to ask for a Kleenex, ask for a tissue or a Kleenex brand tissue. So sometimes that straight line gets bent, and if you're lucky enough to have a really famous brand that becomes so well known that it starts to be leaning in the direction of all the way back around the circle to generic, then it's important to take steps like that to remind the public that it is a brand. So let's have a little quiz and see what you've learned. First of all, take Velcro. What do you think? Is it arbitrary? Is it suggestive? Is it descriptive? Is it generic? It's fanciful or arbitrary. But if you wondered for a minute, is it generic? The answer that the Velcro owners would tell you is absolutely not, but it's probably one of those marks that's leaning that way, and so they're really working hard to make sure that nobody uses it as a generic term. What about Coppertone, suntan lotion people? Is that arbitrary, or is that descriptive, or maybe suggestive? Yep. The great thing about Coppertone is that it hints at something about the product. It's going to give you a copper looking tone, but without more, it doesn't tell you that it's suntan lotion. It just gives you a hint, and that is in the sweet spot. What about this one? National Football League Players Association. Is that generic? Are there lots of those out there? No. Is it arbitrary and fanciful? Well, not really either, because all of those words by themselves are plain English, right? National Football League Players and Association, all descriptive terms. Well, it's descriptive, but it's acquired distinctiveness over time. So people don't think that that's a generic term for any association of football players. They understand it to be a particular association, a particular brand. And Kleenex, I gave you a hint earlier. So you know the answer to this one. It's suggestive, I would say, but at risk of genericide. Because, in fact, you know, it's such a famous, popular brand. But those folks are doing a great job of protecting their brand so that it never becomes generic. So the marketing don'ts, or we like to think of them as the things that make lawyers' heads explode. Please, marketing people, to stay friends with your legal department, please don't request that they approve a new trademark after the whole marketing team is committed to it and it's about to launch. Because, of course, if in fact the lawyers run a trademark search and find out it's really risky, or somebody didn't pay attention to the part about not picking descriptive marks and it's going to be incredibly difficult to protect, nobody's going to want to hear no at that point. It's really important to bring the lawyers in a little sooner and give them a short list. Please don't select a highly descriptive term that will take years to acquire distinctiveness and will be indefensible in the meantime. It's such a bummer when you launch a new brand and then your competitor picks almost the identical word and there's nothing you can do about it. Also, please don't modify or refresh a key brand such that the company's use no longer matches the way it was registered. We're going to talk more about this in episode 2 about registration, but it's really important that if you register a mark in a particular way, that you use it the way it was registered, unless you're making a conscious decision to abandon that registration and start over. And last but not least, please don't commit to a new mark in the US and assume that that means it's available everywhere else in the world, because there are trademark registries in every country. They're country specific. And so if you register a mark in the US, doesn't necessarily mean that it can be registered in Europe or in China or Australia or wherever else you want to use it. It's really important to do that pre-clearance analysis anywhere that you want to use the mark, inside the US and outside. So, marketing do's to stay friends with your lawyers. Ask for legal review of the short list of candidates for the new brand name before your higher-ups fall in love with one name and now nobody wants to hear no. Send that short list and the lawyers can help you rank those in terms of the riskiest and the least risky, and then you can pick a favorite knowing what's risky and what's not. please do select a mark that has at least one non-descriptive word in it, even if some of the other words are descriptive, so that the brand can be protected on the principal register. Ask for a legal review when you're doing a brand refresh or a design change to be sure that you're not going to accidentally lose trademark rights without realizing it, or accidentally put yourself in a position where you can't renew your registrations anymore because your use no longer matches them. Remember that trademark laws are country specific, except a few really unique jurisdictions like the EU, which you can protect with one registration for the whole collection of countries. But generally, country by country is how trademarks are registered. So if you want to protect that mark in more than one country, remember to tell that to the lawyers at the beginning. And last, as a marketing person, familiarize yourself with the registrations that your company already has. If you don't have a list, you should. Ask for it. Say to the lawyers, please send me a list of all of the trademarks that we have, pending, registered, and maybe you even have a list of common law marks. And then think about whether that list really reflects how you use those brands today. If not, you may need to file some new registrations. And as I said, we're going to talk about how to do that in episode 2. Thanks for joining me for Frenemies, Season 1, Episode 1. Feel free to reach out to me or any of my colleagues if you have questions or would like to have more information about the content that I've covered today. All of the episodes in our Season 1, Cross into the Friend Zone, Trademark 101, are currently available at mcguirewoods.com. And keep your eye out for future series that are going to be available soon. So now we have something really fun for you. If you go to YouTube and type in the search, "Don't Say Velcro," you'll get the most hilarious video of singing lawyers talking about trademarks versus generic words. McGuire Woods had nothing to do with this video, but it truly is awesome. So enjoy, and you're welcome. Thanks.